If you're in your home that you own and the hot water heater isn't quite as hot as it should be, right? You can make that decision on your own to just live with it, but you can't do that for tenants. Give the person on the other side of that contract a little more humanity and think about, what would I like if this were my home that I'm living in? I think that level of disputes would be lowered. Here's what I'll tell you from the legal side. Anything in writing is better than nothing in writing, right? Texas does have a structure that is based off of how logic would dictate it would go.
Have you ever lost money on a new construction home, or you had a tenant that didn't pay on time, or you had a seller that did not disclose everything that they needed to disclose? Or you're a first-time home buyers that don't know the rules and the regulation? Well, on today's podcast, I have the very own attorney right here where we're gonna go over all of those things and much more. So stay tuned. We have Rachel McKenna right here, a real estate attorney, where she's here to kind of answer all our questions that I have ready for her. And Rachel, thank you for coming on my podcast and talking about all the questions that my buyers, sellers in real estate.
Well, thank you for having me. It's a pleasure to be here.
Thank you. I guess to start out with, tell me, how can a person know that, or how can they find a really good attorney? And they think that an attorney can do all kind of things, but I know you all have a specific for real estate and different kind of things that you guys do.
Right. So I think that it's really important to utilize the network you have as a starting place, right? And what I mean by that is, if you have any family members who've used an attorney before in that area, or friends, or even turning and asking your realtor if there's an attorney that they would recommend. Usually if you're working with a realtor, they know an attorney, whether they like knowing that attorney or not, right? They know an attorney that they can refer you to. And so using those resources to get referrals, even if that attorney doesn't focus on exactly the legal issue you may have, that attorney almost guaranteed will know somebody else to send you to. And that's the key, is it's a referral game. And so utilize your own network first and then extend beyond that. I urge people away from Google searches, because Google is in many ways a pay-to-play platform, and you're not always going to get the best quality in doing just a simple Google search. So I always start with your own network.
So referrals, reach out to people that have used. And
absolutely, because you want to. Hiring a lawyer is building a trust relationship. If you can't trust your lawyer, then you need to look at hiring another one, because as a lawyer, I'm dealing with people, something very intimate in their life, right? And you're usually hiring a lawyer because there is a problem you cannot overcome yourself, and you're needing advice on that thing, whether in real estate it's your home or your finances or something very important that you need help navigating. You need to be able to have absolute trust that that person will always put you first. And
absolutely right.
Yeah, getting that referral from somebody who has already trusted that person goes a long way to build that relationship.
Okay, well, referrals, make sure you guys have connections and reach out to the people that you know for referrals. Now, leading to our topics, we're going to be talking about, the landlords, the new construction, the sellers, and first-time home buyers. So starting out with landlords, and I work with a lot of landlords, and these are some basic questions they ask me, in which I always probably have to get more clarification by reaching out to an attorney or asking for advice. So the first question that I have is, what legal protection should landlords have in place when drafting a lease agreement?
Well, I really think the most important thing is don't come up with your own lease agreement, right? The state has promulgated forms for really all different kinds of real estate contracts, right? And using a state promulgated form is always going to be your best bet. Those forms are created by a committee of both realtors and attorneys who are constantly reviewing, revising, and editing these to make them so that they are equal and balanced and for both sides of the transaction. And so, the best thing you can do is start by using a form. And if you don't have access to the form, that's where realtors are a great resource, right? They have access to those forms. They're taught in how to use them and properly fill them out. And going back to your first question, if there's a question that comes up, they generally have somebody they can turn to ask a question about a specific provision or some change that might be specific to that property. And so I think those two things, right? Have somebody you can trust. Don't DIY it. Contracts are not a DIY. And use what is out there for your benefit to protect you.
Have you seen any cases that might have happened that they might not have used?
Absolutely.
Yeah. Okay. So this is why you're saying
that were property management companies that came up with their own lease agreement that they thought was better because they didn't like XYZ on some form, and then a dispute came up and it came back to bite them, and I had to have that difficult conversation with them that said, well, you're using a specialized form. This isn't the standard, and sometimes that doesn't work out in your favor.
So leading to that, when you mentioned property management, property management, a lot of people use that when they have rental properties in Austin. They're not living in Austin. They're in a different state.
Right.
Now, because of that, for the transaction, do you advise the investors or the landlords to have the property managers take over the whole transaction, or do you advise have it listed by the real estate agent, get everything done, and if you wanted to go with the property management, you can? Like, what is your take on that? In
many ways, I think it's very dependent on how much control you want to have over the process, right? If you are looking at your rental property as this is a pure income generating thing, but I don't want to have to deal with the days in and days out of dealing with a tenant or fixing up a property and managing it. I mean, there is real work that goes into managing a rental property. It is not a simple thing. That's why there's a whole business for property managers. And so if you're kind of I just want to make money off of this and not worry about it, hire a property manager. It'll be the easiest way to have somebody whose whole job is to take care of that for you. Plus, the benefit of that too is that you've got somebody who, theoretically, if you're hiring the right person, has the knowledge base to protect your interests in a way that you, and not a property manager, may not be able to do. The other benefit of using a property manager rather than doing it yourself remotely from some other place in the country is you have somebody physically there who can go by physically and look at the place. If you're doing it yourself, that's not impossible, but you'll either have to travel here to do it or you're going to have your own connections to go check it out. That can be really difficult. And so, at the end of the day, every person is going to want to have their own arrangement, and by no means do I think you should be a completely hands-off landlord, but property management companies have a real place in that business and can be a real asset to a person who doesn't want to deal with the day in and day out. It's not impossible. It just takes a lot more work, and it'll take a lot more time than you might think it would. Because you're making sure that somebody's house is up to a standard that meets basically the state's standards for renting a house out to somebody. It's not, if you're in your home that you own and say the hot water heater isn't quite as hot as it should be, right? You can make that decision on your own to just live with it, but you can't do that for tenants. You got to be able to go in and fix it and address those issues right away. And so if you're willing to do that and you have the time to do that, awesome, do it. Otherwise, get the help and do it. And
so you said the major issues. What are some major issues that that landlords have to address within the 24 hours?
So big ones, especially here in Texas, right? Losing your AC. That is number one. You need to get somebody out there right away. And with our increasingly erratic winters and winter storms and all of that, if the heat goes out in the middle of an ice storm, of course, that in 2021 we all had power outages and water issues. But if it's something specific to your home that you can get out there to repair, and it's a life-threatening or health-involved deal, you have to get somebody out there to deal with it right away. So AC is a huge one. Proper plumbing is a huge one. You have to be able to have running water, and a the not so fun part of the sewage has to be going out, right?
Yeah.
If you're having issues with that, that's a safety concern. Along that line, mold issues is one that I see a big contention on repeatedly. Most people, there's certain things people want to argue about, right? AC, nobody in Texas is going to argue that that's not a health and safety issue, right?
Yeah.
Mold is a little more questionable because there's mold all around us, right? There's mold in the air we're breathing right now. There's mold that's harmful, and then there's mold that is not harmful, and you are going to find in certain places. And so because there's a lot more of a scale on that and what has to be done to clean that, I see a lot more issues arising in landlord-tenant disputes over those kinds of issues, right? Where it's, how urgent is this? How much do we need to fix it? Is it worth completely breaking a lease over? That's often what it is, where somebody says, it's not that it's not getting remediated, it's either not being done to that person's satisfaction or not being done fast enough. And the person, the tenant, is saying, I need this to be fixed for my health. And if you can't fix it, I'm breaking the lease. And so I see that happen a lot. And the law is a little gray on that.
There's a lot. Yeah. Wow. Okay.
A lot of information.
Good to know, though, like the emergencies that they have to fix. And this is why if you want to make a decision to either do it on your own or have a property management involved in it, one, the importance. Like switching a light bulb may not be as important, right? That can wait. Have somebody go out there. The other question that I have is, what are the most common mistakes landlords make that can lead to legal dispute, and how to avoid those issues?
So there's two that immediately pop to mind, right? And one ties directly into that last question, which is not taking something seriously enough and not moving to do a fix or handle an adequate way, right? Or adequately communicating with your tenant about the repairs that you're gonna get done, right? Nobody wants Joe Schmo, the plumber, walking in on them without notice, right? You wouldn't want that in a house you own. Don't expect your tenant to want that. Communicate with them. Yes, your lease may say that you only have to provide an hour's notice to this person coming over, but is that something that you would like to?
No.
Then, I think if landlords, and on the tenant side too, give the person on the other side of that contract a little more humanity and think about, what would I like if this were my home that I'm living in? I think that there would, the level of disputes would be lowered. The other big dispute I see often is over security deposits, right? I mean, that's a number one thing that gets hit up all the time. There is a pretty clear statutory regime about how landlords are supposed to return security deposits, what can actually be billed against a security deposit. Now, keep in mind, security deposits are not for normal wear and tear. But normal wear and tear is not defined by statute.
No.
Right? And so that is always the big dispute. And, what I would tell landlords looking at that, photograph stuff. And I say the same thing to tenants.
Yeah.
Photograph the condition that you are saying is beyond normal wear and tear, so that if there's a dispute later, you can provide photographic evidence. Often you'll see people only provide a basic ledger that says cleaning or window washing. And that doesn't mean anything, right?
And this is when you're saying, when they're moved in first time, you have that 7 days or whatever, how many days to do, take those pictures,
right?
And write down the items as a moving condition form.
Yeah, moving condition forms are great.
Exactly.
And I love that you brought that up, because I think too many landlords don't make it a priority to get those.
Yeah.
I feel like it is more often than not the case that was never gotten in the first place. It's part of the move-in paperwork, but they never get it returned, and that's a huge mistake.
Yeah.
The more documents you can have to prove up the condition of the home to show that something is beyond normal wear and tear, the more protected you're going to be.
Yeah. And then use that when they're moving out for the security deposit.
Exactly. 100%.
Now, you know how some landlords say you have 7 days to fill in the moving condition. And that's a gray line, I think, again, right?
Right.
They can do it later. It's not like, oh, you didn't turn it in.
Right.
It's between the landlords and the tenants. How can a landlord protect themselves when the tenant fails to pay rent or damage the property?
So there's two different questions there, right?
Yeah.
You know, not paying rent is one of those where I think that the landlord really needs to know what the terms of the lease are, right? Leases will contain, generally, especially if you're using the form, right? They're going to contain all the provisions you need to enforce that lease, right? And so if there's a notice of default period in the lease and you have to give appropriate notice to say, hey, you didn't pay this, or hey, you didn't pay this and now late fees are accruing. It's very important to have open communication about that so that there's no hiding the ball. The tenant can't say they didn't know. There's no argument that the landlord waived those fees. That's the other important thing. And so staying on top of it and tracking it in terms of lost rent is very important. Know what the terms of your agreement are. And then the other important thing is you need to, like any potential legal issue, you need to properly paper your file, right? Send a letter, certified mail and first class mail, that says, hey, you're late on your rent. You need to cure or fix and pay your rent by this date. And if you don't, we'll be taking legal action.
So an email, or that's not enough?
Usually it's not. I mean, here's what I'll tell you from the legal side. Anything in writing is better than nothing in writing, right? Emails are people just want to rely on email, but you do all three, right? And we call it the belt and suspenders. Do an email, send it in the mail, send it certified mail, because when you have to show the court later how you communicated notice, you can say, look, Judge, I got all three.
Yeah. So all three is certified mail, email, and what was the last one?
It's just regular first class mail.
First class mail.
Yeah. And it's just regular mail.
Okay.
Yeah. Certified mail is important because it has a tracking number. And you can track that it was attempted to be delivered. And often, if you're sending it return receipt requested, that's that little green card that you sign and send back. It's proof that somebody got something.
Okay. And then going back to our last question about the security deposit, a lot of the landlords don't know when do they have to return it. How many days usually? I thought it was 30 days.
I think it is 30 days. So it's that is in the Texas Property Code. It's Chapter 92 of the Texas Property Code. And I don't think most lease agreements say when it has to be delivered by. I think they just go by what's in the standard. 30 days is the good go by. And what you have to provide within 30 days is either a full return of the security deposit, or if you're going to take any money out of the security deposit, you need to provide an accounting, which can be as simple as this was the total security deposit and here are the deductions for what we're taking out, and here's what check is being sent to you.
Do they need to show receipts or anything? Or just deductions?
Probably,
right?
So the best way to protect yourself is to attach receipts and photos, right? Okay. The more proof you have, it will never hurt you.
Yeah.
You know, people don't want to worry about it. They want to do the fastest thing possible. But if you do it right the first time, you're protecting yourself at the end.
Okay. And
the other thing I'll say is, even if you are using the entire security deposit to either pay back rent or pay unpaid rent, fix different issues, whatever, and you're not returning anything to them, you are still required to send that accounting that's the breakdown of how their security deposit was used.
I see.
That's what's required by statute, no matter what's in your lease. And just have it a breakdown with as much information as you can provide. The more detailed it is, the more difficult it is to dispute it.
Okay. And I think on a turnaround, like when they're changing tenants, I know, what are the standards that they have to do? And changing the lock every time.
Right.
Is there anything else that they have to do on changing the tenants around besides that?
So cleaning. I think you need to have it cleaned every time.
Every time.
Have it professionally cleaned every time. You don't have to have it professionally painted or anything like that. I mean, if it's ugly, then do it. But that's not required. You can do spot painting for things like that. But just making sure everything is in general working order, or be prepared to get a repair request shortly after they move in.
After they move in, okay. This is where the moving condition form will taking place for that. The other question is, what are the legal steps a landlord must take to properly evict a tenant in Texas?
So that's another one that's very statute driven, right? And so there is a minimum notice period that's required, but that notice period varies depending on what's in your lease and what kind of eviction you're doing, right? If most leases will state how many days notice is required, and when I say notice, we're talking about a written notice, usually posted on the door of the property, as well as mailed, right? That's another one where you want to cross all of your T's, dot all of your I's, follow your lease to the letter if you have a lease that tells you what notice is required, okay? And so there's always a notice period that's required before you can even file suit to evict somebody. And so the very first step is that notice period. In some cases it's 3 days. In some cases, like if there's no lease and the person claims that they're living on a month-to-month basis, then it's 30 days. It really depends on what your tenant situation is, and I would highly recommend getting an attorney involved if you have questions about what those notice periods are. So you have to provide notice, and then once that period has elapsed, then you file suit in small claims court or in justice court. That process is very easy. The justice courts, especially here in Travis County and in Williamson County, it's all online, and they make it where you can do it without an attorney. You go through their portal. It has to be filed in the county where your property is located, right? And you fill out the form online. The clerk's office will help advise you on how to get that served on your tenant, and then you have to wait for them to answer or for the court to set a hearing. Eviction hearings happen fairly quickly, but quickly is relative in the judicial system, and it can still take 5, 6, 8 weeks to get somebody evicted. That's something to keep in mind when you're going through this process. If you can get somebody to reach an agreement with you on the move out, it will always be faster and cheaper than evicting them. But sometimes you have no choice and you have to go through that process.
Yeah, because I feel like as soon as they know that this is happening, what can they do to the property? Right.
That's a big one. A lot of tenants will go in and damage the property and take anything of value and steal it. I shouldn't say a lot of the tenants. There are bad apples, right? Yeah. There are bad apples. And the best thing you can do is just document those damages and seek to recover them. That's the best thing to do.
Yeah. I just had a case that a landlord had told me that his last tenant had destroyed the property. They didn't get to the point to evict them, but they didn't pay for months. Yeah. Destroyed it, left it. They had to put in at least $20,000 to $35,000 in repairing it. But also that they didn't use a professional to get the background screening to do that. And just finding that tenant. So important to get all the steps in before you finalize on a tenant. Right.
And I'll say too, there are sometimes when you just don't know what's going to happen. Yeah. And in those cases, the best thing to do is just to make sure that you've papered up your file as best as you can, right? As long as you take those steps to do it and don't cut corners and take shortcuts, generally you'll be okay. But I mean, it's gonna happen. It happened to my parents, and oh gosh. So you can be as diligent as you want, and there are gonna be ones that slip through the cracks. Yeah.
Even if you do all the background screen, everything, you just don't know. They look great on paper, but once they move in, you don't know what happens in their life, right? Anything can happen. Exactly. So as a landlord, there's always going to be risks.
Right. So 100%.
Yeah. Now, for the security deposit, I know a lot of landlords ask, hey, 1 month rent is good, but they can collect as much as they want, I'm assuming.
Right. It's all a contractual
Okay.
term. 1 month's rent is standard, but it can be whatever you set it up to be, because it's, it can be, 1 month's term for this, but then if you want to have pets, it's another.
Exactly.
The pet deposit.
Pet is a whole
right?
different thing. Because
Whole
what if they
different
say,
thing.
oh, this is an emotional support?
Oh my Lord, that don't get me started.
Well, doesn't apply then.
Yeah, exactly.
That we can go over it next time. But now, as a landlord on their property, if they wanted to put it under LLC or a trust, what do you advise on that take?
So I think the key distinction here is in many ways what the purpose of putting it into another entity is for, right?
Okay.
An LLC is a business entity, and a trust it's considered an entity, but it's a different beast, right? An LLC, which stands for limited liability company.
Ask, yes.
And you can have all different kinds of business entities. You can have a corporation, you can have a limited liability company, a limited partnership. They're all different kinds of business entities that have, depending on what you choose, different levels of liability protection for the owners and the members of that, and also different responsibilities, right? The benefit of an LLC is that it protects its members from personal liability, right? So if the two of us created the R&R LLC, what that means is if R&R LLC owns this property and rents it out, then any lawsuit against the landlord would not be against us individually, it would be against the LLC, right? So that's why LLCs are great, is because if you want to kind of protect yourself from future lawsuits or things like that, it's great for forward looking, just to asset protection, essentially. Now, a trust is a little bit different. It's a trust is a legal instrument that says, I'm creating this, let's call it an account, right? This is an account that is going to be supervised and managed by a trustee for the benefit of another person, right? And usually it's for the benefit of what's called the grantor, the person making the trust, right? And the trustee is a different person. And so trusts get complicated because to truly gain the protection of a trust, it depends who you are in that, right? Are you the trustee, in which case you owe a fiduciary duty to all of the beneficiaries of that trust? Or are you a beneficiary of the trust? Are you just the grantor who puts stuff into the trust? That gets very complicated very quickly. There's also different tax implications for a trust versus an LLC. Which I don't have enough knowledge to educate everybody on, but there's significant differences between them in terms of how to which one is preferable.
Yeah.
It kind of depends how much control you want over the asset itself, right? The property is an asset. If you want to maintain absolute control over it, an LLC is probably the better way to go. But there are all different kinds of trusts that you can set up that could give you that same level of control and just protection for your beneficiary, whoever that person is. So in many ways, it really depends what your goals are and why you're seeking to do it in an entity versus individually as a person.
So have you seen one versus the other more?
I would say I more often see rental properties specifically in LLCs.
And LLCs, yes.
I see personal property in trusts because trusts are utilized more as more in the probate and estate planning situation, right? So say I buy my house in the revocable living trust of Rachel McKenna, it's for I'm the main beneficiary, but if I pass away, my kids or my husband will be the beneficiary, the remainder beneficiary to get that. And it takes my home out of probate and avoids the costs of probating over that home and keeps it in the private sphere so it's not public knowledge that who got my house and how it's passed. So it's very dependent on what your goals are. I think trusts are better personally for estate planning, for something you want to keep in your family and owning directly versus if it's something you're trying to earn money and income on. An LLC might be a better situation.
That's a good point. Leading to the next question with that one is, a lot of the clients are wanting for the trust, right, for their kids. Now, let's say that if they just put the name of the child on, like, I'm putting my kid's name on this property.
Right.
Eventually, they're going to end up paying whatever the capital gains or the
gift
value
taxes.
of gift taxes that end up doing that. Versus if you put them in a trust, I've heard that if you do pass away, then it automatically goes to the kids and they're not paying that. Is that what you...
So it's not quite.
Okay.
So when you directly give somebody something, right? So if I bought a house while I'm living and give it to you, you are going to pay a gift tax, right? And at any amount over, and the amount changes. When I was in law school, an obscene amount of time ago, it was $14,000 per year was the annual gifts that you could get before you'd have to pay taxes on them, right? I don't know what the number is now, but if I were to give that to you, anything over that $14,000 limit is now taxable, right? Whereas if it passes through estate taxes, you're going to pay Uncle Sam at some point, but the estate tax threshold is significantly higher. Most people don't even meet that. It's estates over $5 million, or again, it was when I was in law school.
Yeah.
And that number changes. And so it's always better if you're doing something through kind of an estate process to avoid for tax purposes, to do it where it's passing upon death versus a gift, because gift taxes are going to be, you're going to pay a lot more in gift taxes because you have a lot smaller of an exemption.
I see. So I'm a little bit like, oh, okay.
Yeah.
Thinking about the future now with the kiddos. So the best way, let's say if they wanted to do something like this for their kids in the future, to get a trust.
I think that's what a lot of folks will do as kind of a way to buy something in the name of somebody else, especially if you're buying for somebody who's a minor.
Yeah.
You can't buy property in the name of a minor, but you can create a trust for your child and name an adult as the trustee. You could even name yourself as trustee as long as you're, not a beneficiary. You can't be a trustee and a beneficiary, right? You can... but you can be the trustee for your child's trust until they reach maturity or until you pass away. It's a trust asset, right? And the thing to think about in terms of, ownership and liability and taxes is a trust is its own entity, right? And the trustee takes actions on behalf of the trust. An LLC is its own entity, and its members take actions on behalf of the trust. But at the end of the day, the ownership is in the name of the trust. The ownership's in the name of the LLC. And so from a on paper, contractually tracing assets, it's important to differentiate between the entity and the individual.
I see.
And there are benefits to doing things via an entity.
And you can't do both.
You can... It depends.
It depends. Okay, because I'm thinking, LLC, but yet you want to have a trust.
You can have... So you can't have for example...
Okay.
Your home.
Yeah.
Right? You own it in the name of an LLC.
Yes.
You can put that LLC ownership in trust. Okay? But what you're putting into trust is not the property owned by the LLC. That property is owned by the LLC. What you're putting into trust is your ownership interest, which could be 100% or it could be 50%. Your ownership interest into the LLC. The LLC for government and tax and business purposes is like I'm an LLC, right? And I'm just broken up of different people.
Yeah.
Does that make sense?
Yeah.
Yeah.
Okay. Wow, great information and the trust and the LLCs. Okay, so my next question, I think this is another very asked question, is for a will, why is it important to get that done through an attorney versus an online? Because an online, they have a flat fee, much cheaper, versus each attorney have their own fees. So why one versus the other?
Okay, so I'm biased, but I think it's always better to go through an attorney because online platforms are not going to be as nuanced per state, right? They will have kind of a universal, this is generally what it goes in a will, but it's not always applicable, right? Whereas if you use an attorney, you're going to have something that's a lot more customized to what your needs are. And you may be thinking, well, my estate's not that complicated. I can just do it online, $50, LegalZoom, it's great, right? LegalZoom is not this. AI is incredible. And some of these online platforms are great, but they're not foolproof. And so the biggest risk you run by going through one of these, auto-generated companies is that it's going to generate something that's not correct on the law or not what you want, right? Not what you intended. And those platforms don't always adequately explain the consequences of the choices that you're making, right? And so it's always better to go through an attorney who can customize your estate plan for what works best for you, right? Again, talking about if you have multiple properties and you want to protect them, a will may not even be the best choice for you. You may be looking at setting up trusts. It's always better to go and talk to somebody about what exactly your goals are, what you want to happen, and then let that attorney advise you on how best to do it. It's just a way of planning for the future, and an attorney is always going to be able to help you foresee possibilities than a simple form online.
So we talked about LLC, trust, how that is. Can you explain a little bit on what actually a will is?
So a will is a document, it's a legally recognized document that says, when I pass away, this is what I want to happen to my stuff. I think there's a lot of false, or I say to my stuff, my property, right? There's a lot of false stuff out there where you envision, oh, my cup is going to go to Auntie Tim, and this is going to, this piece of art is going to go to my daughter Regina, right? That's not usually what it looks like. You can have specific bequests in there if you want, but typically what wills do is they say, look, my house that I own, I want this house to be passed to my wife. And if my wife predeceases me, because you want to be able to plan so that you don't have to redo it every 2 years.
Yeah.
If my wife predeceases me, then to my children in equal shares, or to say you have a bad relationship with somebody who would normally inherit under Texas law, you can specifically write that person out of the will. Or say you are early on in your family life and you haven't had all your children yet. If you don't want to have to rewrite your will upon the birth of every new child, you can say to my children in equal shares. And it identifies, here are my children at this time, but any person born after this will also be considered one of my children, that kind of thing. And so wills handle real property, so house, a piece of land. They also handle personal property, right? If you want to make specific requests to people in there, great. But if not, personal property includes things like your bank accounts, your furniture, your fine jewelry, all of that's personal property. And then there's always what we call the remainder clause, right? What happens to the rest of the estate that's not easily classified as one of these. Or if something happens and say I said my house goes to Bob and then Sue and then Timmy, but Bob, Sue, and Timmy aren't here anymore, what happens to it? It goes through the fourth option in the remainder clause, right? It can also, wills are also great because they can set up trusts, right? If you've got, I have a 6-year-old and a 4-year-old for my entire life. God forbid something happens to me and my husband, I want it set up so that my estate goes to them. But if they're minors, they can't take, right? So what I'll have to do is set it up so that a trust is created by my will, in which I name a trustee and a guardian to take care of them as long as they're still minors, right? Those only apply if they're still minors when I pass away. Otherwise, they're adults, and that doesn't have to be enforced. But I mean, that's why it's important to have a will, is because it's just, you want to have all of those things laid out. And to be a valid will, which you didn't ask, but it's very important, because a lot of people think, oh, if I type something up and print it out and then just put an X, that may not be enforceable, right?
But for Texas, is there, like, let's say if we as parents go away, automatically, isn't there a rule that it just goes to the kids?
The intestate laws is what you're thinking of.
Yes.
Yeah, intestacy.
Okay.
So Texas does have a structure that is based off of how logic would dictate it would go, right? If, again, using my husband and I as an example, if I pass away, everything goes to my husband, because my children are the children of of our union. But say I got frisky and I've got another child, not from my husband, or my husband and I get divorced and I marry somebody else, all of a sudden it doesn't just go to my spouse. There's a division in the community property and the separate property, right? We're a community property state. And how that gets divided up gets complicated, right? In your normal, like, nuclear family setup where there's no drama, intestacy is great. But if, but it can take longer to go through, because you have to prove up who the heirs are and all that. Wills are important because they require less in court. So if you want to take the best care of your heirs, do a will.
And then you're saying you don't want to do it more than once. Now,
right?
The fees, would that include the same if you're doing it once, or changing anything on there?
So it depends.
Okay.
It's my favorite answer. It depends. It kind of, I'm sure it would depend who you're using, right? So like my office, for example, we do estate planning on a flat fee, usually, right? If it's a simple estate, husband and wife, there's a flat fee for that. If it's just one person, flat fee for that. It's when you need more complex estate planning, like you're creating 3 trusts and a will and LLC, that's a lot more complicated. You're probably going to pay hourly for that. But if, say, you're using the same attorney to just update your will later on, and they're not recreating the will, then you're, you don't have to pay as much, right? But if say you went to me to draft your will, and then 10 years down the line you go to another attorney, you're probably going to have to pay another fee to get a new will, because the law will have changed. And a lot changes in 10 years. Your whole expectation and plan may have changed. And so it's just something to keep in mind when you're updating the will. And when you write your will in the first place, it goes back to why it's important to have an attorney. An attorney is going to help you think through potential consequences of different selections or different verbiage that LegalZoom and some of those other platforms aren't going to have. One of my colleagues I was talking with this morning about estate planning, and he said, estate planners are often called disaster predictors, because they have to sit there and think about what happens if we both go over the cliff in an airplane and die at the same time, right? Or what if I die, but then my husband doesn't die for an hour? How long did he survive me? Or he's in a coma for 6 months. Does he take, because all of that impacts who takes what under the will.
Yeah. And that's what we have said for us. I'm like, God forbid, if both of us go,
right,
my sister knows she's taking my twins, but then do they all have to fight for it, or do my twins have to agree they want to go with her?
Right.
If there's no will, right?
Yeah, if there's no will, and when you have children, it is so critical to have a will, because that's the most effective way to make sure that your children are taken care of by the person you want to take care of them.
Yeah. And when do you advise to get that done?
Really, everybody should have one, right? But especially if you have kids, I think it's important to get one done. Even if it's even if you plan on having more kids, because like I said, you can write it so that it will include any other children born.
Okay.
But really, it's important as soon as your who takes when I die gets more complicated than just mom and dad.
Yeah.
It's time to start thinking about a will.
Got it. Good to know. Well, now we're going to move on to our first-time home buyers, or just generally any home buyers.
Yep.
What are some common legal pitfalls first-time home buyers should be aware of when entering into a contract?
I think not carefully reviewing seller's disclosure notices, or worse yet, not doing inspections. I really think that it is so important to not waive inspections and to be fully aware of what you're buying going in, right? Texas is a buyer beware, as is state. And that is an enforceable clause in Texas. And so, I get a lot of cases. A lot of the work I do is when, somebody buys a house and it's not what they want it to be, right? That conversation is always, well, why do you think the seller knew it and didn't disclose it? Because unless you can prove that the seller intentionally didn't tell you something, those cases are very difficult to win. Because that as-is clause is powerful.
Is that what it says, Texas non-disclosure?
When we say a non-disclosure state, that has to do with we don't tell the appraisal district how much you paid so they can update your taxes.
Yeah.
That's what that means. We don't have to provide information about your sale to the public.
Yes.
But in terms of disclosing what's related to the state, or what's related to the property, that's a whole different ballgame.
So leading to what you just said, sellers have to disclose. What exactly do they have to disclose? Are they legally liable to disclose everything, or?
Well, what I tell people, my advice to people is that is disclose. You will never get sued for over disclosure, right? And the more as a seller that you can prove that you showed them everything, the less likely there will ever be any issue that comes back to haunt you. As you know, there's a mandated form. There's a state mandated seller's disclosure notice that has to be filled out in the usual transactions, right? If you're selling a home that is a pre-owned home that's been lived in, that's not just a lot, then if you have experience there, you have to disclose any known defects, right? And that seller's disclosure notice is pretty darn detailed. One of the things that I think gets people confused when they're filling it out is they're like, do I have to disclose everything that's ever gone wrong? Like, what about that plumbing issue that happened 10 years ago that we fixed and haven't seen since?
Yeah.
That's where it gets a little more gray, right? Because again, over disclosure is your friend.
Yeah.
Saying, hey, we dealt with this, we haven't seen any problems since, is usually not going to be any problem. Whereas if you didn't tell somebody something and they find out later that you had this exact same plumbing issue 10 years ago, then you're going to get sued.
Yeah.
But, what do you have to disclose? If you know there's a defect existing in the property, you need to disclose that. There are certain health and safety things that's in the third section of the form. And those are things like, has the property ever flooded, right? And they say water penetration. That could mean, your bathroom flooded because a pipe broke and burst through the walls. That creates a risk of mold. So that's something you need to disclose, right? Or roof issues, or have you made insurance claims on the property? All of that is important to disclose because think about it this way. If it could be a problem that is still lingering, you think you fixed it, but you're not sure, disclose it. Just disclose it.
Random question I have asked, my buyers have asked.
Yeah.
The death of the family.
Yes. So
then, yeah, there comes the haunting stories.
yeah, that's a big one. So technically, you only have to disclose a death in the property if it's the result of a violent death, right? A murder.
Yeah.
I think suicide is right on that questionable line. You know, like, and it goes back to, again, is there some kind of underlying health concern in the home that has to be disclosed, right?
Yeah.
If somebody dies peacefully in their sleep, that's a lot less of a concern than there's blood all over the floor and did that get cleaned up properly and that kind of thing. And so, yeah, I get asked that a lot.
Yeah.
And, you know,
yeah,
it depends.
Don't be afraid of the spirits in the house.
Hey, just get a good sage candle. You'll be fine. Ghosts are your friends.
Yes, yes. So now going back to the home buyers, how can a real estate attorney help the home buyers understand the closing process? Or, I mean, is it, even if they're having a real estate agent, right?
Right. So, you know, in Texas, we don't typically have lawyers involved in the transaction unless they're needed, right?
Yeah.
And so I would say probably 9 out of 10 closings happen without a lawyer ever looking at the contract, whether that's good or bad.
Yeah.
But where a lawyer can help is in a couple of different ways, right? If you have something about your transaction that is just a little bit different, right? Like like I had one where the person was buying lot A but wanted an option to purchase lot B, or they were buying them at the same time but the pricing and the financing was different, right? That's when you need a lawyer to help you through that, because legally a real estate agent, they can fill in that promulgated form, but anything changing the material terms of that contract has to be drafted by a lawyer, just for the protection of both the consumer and the real estate agent, right? In terms of the closing process, you don't have to have a lawyer there, but it is very important to read what you're signing, right? At closing, what you're going to be signing are, if you're getting a loan, you're going to be signing the loan application and all of the loan disclosure documents that the lender, by law, has to give you, right? You're going to sign something from an attorney saying you recognize that an attorney drafted this paperwork and that this attorney represents every transaction that rolls through here and you're okay with that. Or, you know, since proper names on deeds are very important, you'll likely sign something that's a name affidavit so that we know that you are a different Jane Smith than the other Jane Smith next door who bought this property, right? And then also there's title documents. The documents themselves, if you're not looking at them every day like I am, can be very confusing. I look at them every day and it's still confusing. Yeah. So, you know, it's just important to read through those. If you have a question that comes up during a closing, that's when it's important to pick up a phone and call an attorney. Because you should never sign a document that you don't 100% know what the consequences are if the worst thing happens.
And that's the thing, when the clients tell you that, hey, we've got this contract. Now, the next question is going to be leading to this, like, difference between a pre-owned versus a new construction contract, right? What should the buyers be aware of? And to me, they've asked, new construction contract are like 30, 40, 50 pages, depending on which builder that is.
Right.
And the sales rep that's representing the builder is not going to go over the whole thing.
Oh,
because
absolutely not.
They say it's not their job. For a real estate agent, we can't tell you what this stuff is either.
Right.
So it comes down to you guys.
Yeah. Well, and here's the interesting thing, right? We were talking in terms of leases about state mandated forms, right? State promulgated forms, not necessarily mandated. You can write whatever contracts you want to write, but there are state promulgated forms. that are created by these committees. And there is a new home contract that the Texas Real Estate Commission puts out, and that can be used, and it has all the basic terms. But you put your finger on it. Most builders don't use those. They use their own contracts. And the reason that they do that is because a builder's contract is always going to favor the builder. And so what I would recommend is, if you're signing one of these 30, 40-page contracts, say you're buying, a house that's $500,000, $750,000, more than that, and they're requiring significant funds to put down to start, have an attorney review it. Even if it's just to say, here's the positives and negatives, here's a brief of what could happen. I get calls all the time, of people who said, oh no, I'm in this contract, I've paid $80,000 to this builder, they're over a year late, what can I do without losing my money? And very often I have to say, there's not a lot you can do. That's non-refundable.
To be aware of that. And that's kind of like getting your home inspection, spending thousands of dollars. Why not get an attorney also to review it, and what you're getting into.
And the fee that you will pay an attorney to review that contract and tell you what your options are is significantly less than the potential loss you face.
Yes.
If you go into a contract not knowing what could play out.
And you probably just answered my next question, is should the first-time home buyer hire a real estate attorney even though when they're working with a realtor, is because of these issues that might have come up.
Yeah.
Now, we talked about the sellers and what they're obligated to properly disclose in Texas. Now, how can a seller protect themselves from legal claims after the sale has closed?
So, again, I go back to disclose, right? If you disclose everything that could potentially affect a buyer wanting to buy a property before you close, you're protecting yourself, right? Okay. Now, but there are going to be things that a buyer, because it always happens this way, a buyer's going to come back and say, I moved in and that leaky faucet that you thought wasn't a problem really is a problem, or like that septic tank was, you knew it was going to go out because you had it pumped 6 months ago, right? Can't tell you how many cases I've had about septic tanks.
Wow.
And the best thing that you can do as a seller is really just know your timeline in terms of like what have you had to deal with that thing, right? If it's a septic tank issue, talk to an attorney right away. First of all, don't answer a demand from a buyer without talking to an attorney, right? And because a lot of times sellers the buyers will just reach out to the sellers, and the sellers and the buyers will have a dialogue, and something will get said in that dialogue that leads to the lawsuit, right? And so I would really caution sellers from having a dialogue with their buyers after they've closed. I just think that leads to trouble. I'm not saying don't be friendly, but you really
keep a little bit of a distance.
Conversations after closing do never fare well for the seller.
No. And then when we say disclose, that's for the seller to put it on their seller's disclosure. Don't have your agents fill it out. No.
And if you're an agent watching
don't do that.
Don't fill out the seller's disclosure notice.
Yes. Big no.
Don't do that. Yes.
Yes, that has been asked a lot, and I'm like, I am not the owner of the property.
That's
Please
right.
do not ask that question. Now, another question is, are there any legal when selling a property? How should the sellers handle? Are there any legal considerations when selling a property, and how should the sellers handle them? Especially with the contingencies, let's talk about that, right? Or as is property. There's two different questions to that.
Right. So let's tackle that in pieces. A contingency is when your contract is contingent upon another condition happening, right? Most often you see those where the buyer is saying, I will buy your house as soon as somebody buys my house.
Yeah.
And the dangers of those, and the reason why those are very often on the buyer side, buyers agents are telling home buyers, try not to make your offer contingent, because that creates a whole lot of risk for the seller, right? If that buyer, if their contract falls apart, well, then yours likely will too, or you'll face substantial delays, or, you know, if everything runs smoothly, it's great, no problem. But how often does it actually go smoothly? Yeah. Any delay in the contingent contract will delay your contract, and so it's just something. It's not an impossibility, and in certain markets, it's unavoidable, right? But it's just something to be aware of. And if you're going to accept a contingent offer, you have to know that you're going to be flexible, right? If you can't have flexibility in the terms and your schedule for closing, do not take a contingent offer.
Simple as that.
Yeah.
Yep. Now moving on to new construction, you know, one of our favorite topics here. What should the buyers, like you talked about, what is one thing the buyers should look for in a builder's contract?
I think it's really important to look at a couple of things, right? If you're paying any money up front, you need to know, is that money refundable? And if so, what makes it refundable, right? More often than not, if you're paying any money up front, it's non-refundable, right? Yeah. So keep that in mind.
And we've had, actually I've had clients lose up to $130,000, $150,000 right, with the spikes of movement that we've had in Austin.
Exactly. And there's not a whole lot to do. Those contracts are set up so that you're agreeing that you're buying this
to favor the builder. Now, exactly, can the contract be changed? I mean, have you ever seen that?
Not in most of the situations that are common, right? Yes. If you're going into a new development, like, you know, there's a bunch going up in Lago Vista right now. If you're going into a development where they're selling batches of homes, they're not gonna negotiate. Those big home builders are not gonna negotiate those contracts because there's another buyer lining up to buy it.
So make sure before you try, you know, go under contract that you know that what are you going to be losing, how much you're going to be losing.
So that's number one. The number two is you need to know what is considered the timeline for performance and what a default on the contract would be on both the builder side and the buyer side, right? A huge thing that came up in 2021 and 2020 into 2022, really, that whole 3-year time period, was we went through that crazy rise in labor costs, material costs, all of that, and construction was substantially delayed. I mean, substantially delayed.
2 years it took for my clients to finish finish their home,
and
the cost went high.
Exactly,
from what
the
they
cost
were
went
in.
up.
Yes.
And I've had to handle multiple lawsuits, which were all different based on the contract, by the way. Yeah. They all came out differently, where the builder tried to raise the price. That's the other thing. Make sure that whatever you're agreeing to pay is not something that is changeable. Know that amount and be sure that it's
and it
that
should be
amount.
set in the contract.
Should be set in the contract. You should know exactly how much you're paying. See if there are deadlines for when something is supposed to be built. You know, I'll tell you, most contracts now, because of that shift in 2020 to 2022, where it took 3 times as long for a house to get built than it used to, most builders have modified their contracts so that it's a type of force majeure clause, right? They can say that, well, shifts in the market and availability of material and lumber, those are outside of the builder's control. We can take as long as we need to take to build it, and you just have to wait.
Yeah.
So it's tough. It's, you know, I joke sometimes that I'll never buy a new build contract because there's so many pitfalls. Yes. And that's not entirely true. But I just think if you're going to buy a newly constructed home, do it with your eyes wide open. Know exactly what you're getting into and have it be something that you're committed to, because if you're signing that builder's contract, it could take longer, it could be more expensive. Things are going to happen over time that you just can't predict. So gauge how committed you are to that
Yes.
property
Yes.
before you sign on the dotted line.
Yep. And make sure you have your team with you, because if you're only working with a new construction sales rep, they're going to be
100%.
at that. And
My clients who have had their own realtors have been significantly more successful in protecting themselves in the eventual, in a default
Yeah.
of the builder than clients who didn't have representation.
yeah.
Absolutely. I think it's way too common where you'll see a buyer who says, I don't need an agent to help me with it. The seller's agent is helping.
Yeah.
The builder's agent is helping me. That builder's agent is not your agent.
No.
They have no duties to you.
No, they don't. They're
Get
working
your
for the
own
builder.
representative
Yes.
in there. Yeah.
Wow, so that was great information. Now we're gonna end it with our rapid fire questions.
Rapid fire.
Yay!
Let's do
Okay.
it.
So what's the biggest legal mistake home buyers make?
Not reading the contract.
Okay. Should every real estate transaction involve an attorney?
Not necessarily.
Okay.
Not in Texas.
Not in Texas. Yes, it's different places, but
Different
not in
states.
Texas.
Yeah.
What's one contract clause that's often overlooked but crucial?
The as-is clause.
As is.
Absolutely. The as-is clause is very often overlooked.
Okay. What's your top legal tip for first-time home buyers, or just any home buyers?
Really get your inspections done. Make sure you know what you're buying. Educate yourself. It was more than one tip.
No, that's great. All good things for the first-time home buyers to look
Yeah.
out, or just the normal, regular buyers. And the last one, what's the most common real estate legal issues that could have been avoided?
Failure to disclose. Those are the ones that I see just over and over and over again in different iterations of them. And that's why I disclose. If you think it might be a concern to your buyer, just disclose.
Just disclose.
It's better to negotiate it up front than be sued on the back end.
Yeah. Well, I really appreciate your time and talking to us
Thank you for
about
having me.
not just a lot more than what I had on questions. So guys, you've learned a lot. If you have any questions, let us know, comment them below. But thank you for watching, and we'll see you next time.